We do the full range of employment work. Most of our clients are employers or senior employees. Most of our cases tend to involve something more than what you might call a straightforward, very simple breach of contract type claim. That obviously has involved notice pay, for example, holiday pay, that sort of thing. But very often it will also involve issues of unfair dismissal, perhaps, other statutory claims like discrimination or whistleblowing. And very often the issues involved like equity issues, shares or share options. Those come up a lot with good leave bad leave provisions. There's a lot of confusion about those. There's no such thing as a defined good leaver or bad leaver for general purposes. It's always according to the contract. And one issue that often comes up is when the share option scheme, for example, says this is in the discretion of the company, and the company says, oh, well, that's our discretion, we've decided it. But actually it isn't as simple as that. The company's discretion has to be exercised in the right way. So sometimes we'll be advising the employer on how to go about exercising its discretion properly, which of course means in a way that can be defended in court, or we advise the employee about whether their employer has done the right thing and whether there are grounds to bring a claim. We often also do a lot of advice on restricted covenants, post-termination restrictions, non-compete covenants, that sort of thing. Those are a very complex area, both in drafting them for the employer to make sure you get them right and they're going to be enforceable. And then if and when an employee is leaving, are they going to be enforceable? Does an employer want to try to enforce them? What are the risks? What are the costs? For an employee, can you walk away from them? Are they likely to be enforced against you? What are the risks that you take as an employee if you try to walk away from them? That's a very complex and live area that we deal with a lot.